Thank you so much for joining me today. I'm going to be continuing the Emerson Bar Review expansion series, and this is number 11. So, if you're new to the channel, please considering subscribing, giving a like. It helps the algorithm. So, without further ado, I'm going to go over some information on law. And what I'd like to tell you is I could probably put some timestamps in here later on that will let you know where we're in the nitty gritty and what the topics are so you can jump to whatever topic you're interested in. So, last time we talked about defamation. Now, a lot of times, something that goes with defamation is invasion of privacy. They sometimes go hand in hand. And the reason is because of what happens. So, if you can remember this, if you've taken law classes, maybe you can remember the four areas. The E's for defenses, so I'm not going to even put that in there. But in a minute, we're going to talk about the quick outline of this and what to put in here. If you can think of them off the top of your head, that would be great. If not, I'm going to go over it in a minute. I'm going to talk about a case that has to do with invasion of privacy. Thought it was interesting. You don't need to know this, but I thought it might add some interest to the story. So, what we're going to do is expand on what Emerson has been saying. Here is a snippet from his video. The link is going to be below where you can watch it, and it starts at 7:20 and then it goes to about 11 minutes. He only spends a couple minutes talking about invasion of privacy. He gives some examples. He gives an example of a politician that is photographed. He said it's from a real case. I could not find the real case. I looked in my Gilbert's outline. He said it was in Gilbert's. Maybe his edition of Gilbert's is different. I have the Gilbert's black letter law outlines. I couldn't find it. I got chapter 9 on invasion of privacy. Anyhow, if you know where it is and you find it in Gilbert's, let me know. But what he said was there was a politician and he went to a protest by a bunch of Nazis. And he's not a Nazi. But news people were there and they took photos of him in front of the flag and then published it, which was giving a false light. It was giving an image of him with an implication that's untrue. So there's four forms of invasion of privacy, and false light is one of them. And I just gave you an example. Now, I can take you over to an article I found because I was trying to find what case he was talking about. He said it was a real case. And so I was looking for the case. And guess what I found? June 15th, 2020. Trump is photographed in front of Nazis. Or Nazi symbols. So they're saying, are these real images? And you can see the post here. They're calling them a prankster. Does the prankster know they can get sued for false light and suffer damages? Well, the video is entitled Nazi at Trump Rally, Social Experiment. Are Trump supporters Nazi, not Charlottesville? Well, anyhow, it just depends because really the thing with the false light is, are you a public figure? Are you a private figure? I could not find that case, but oddly I found this other case. So anyhow, let's just go over the 5 things that you need to know for exams, perhaps. So misappropriation is the first one, or it's appropriation. So what that is you take someone's picture, name, or likeness, right? It's unauthorized use, and it's either theft or unjust enrichment or commercial purposes. So a lot of times, news stories are put up sort of as clickbait because they run ads on them, and then they make money giving you the news. And sometimes, if it's really sensational, a lot of people want to look at it. And so, if they get something really catchy and outlandish like that, they think, oh, well, here's a story, but it's a misleading story. Now, with the misappropriation, this is more like taking somebody and making money off of them without their authorization. So they're using it for commercial purposes or something like that. Kind of mix the two together, but it's a type of invasion of privacy, right? Sometimes you will have overlap. You'll have a defamation suit and an invasion of privacy, like I just said a minute ago. Now, intrusion upon seclusion. This case that I'm about to talk to you about at the end, the Hulk Hogan case against Gawker, and you probably may or may not have heard of Gawker. They changed the website a lot, but there's a Wikipedia page on them. I kind of caught up to speed. I was following them in 2016, and they had to declare bankruptcy due to the lawsuit. There was a couple of different hearings, but anyway, it involves it involves intrusion upon seclusion because there was a videotape of Hulk Hogan in the bedroom doing intimate things with someone that was not his wife. And it was a tape. Somebody videotaped it. I don't know the backstory too much, but from what I heard, it was sort of a setup. But who knows? You know, there's a lot of different people saying different things. And who has time to dig down to the bottom of it? But basically, Gawker wound up trying to appeal and all this other stuff. And so basically, they had a salacious, they still do now, because actually, it was really sad because they stopped operating Gawker. Gawker was, I'll show you how you can do this. Maybe I'll do another video on it, but if you go to archive.org, they have a web crawler, and it shows different stages of a website. And if the site's down and the history of the website, you can see how it changes over the years. But anyway, so here, he filed invasion of privacy, infringement of his personality rights. So basically, that's misappropriation. I guess, you know, they did it, or you could call it misappropriation or appropriation. Now, different jurisdictions are going to have slightly different language. So, if you're taking the bar exam, just go with the California or whatever the state you're in. And so you've got these three. Now, this case was heard in Florida, and it's a very interesting case to me. So basically, it's journalism, right? They gave 115 million, the jury did, in compensatory damages to Belia, otherwise known as Hulk Hogan, and 25 million in punitive damages. Okay. Now, I was watching some of the trial. There's some videos of the trial. I might have seen it on YouTube or something. But in there, I watched the attorneys talking at trial, and they were like, for the purposes of this, they're doing a directed verdict that Hulk Hogan is a private figure. So with a public figure, they have to prove malice. Hulk Hogan or Belia did not have to prove malice in this publication. Now, if you look at the history of the website, Peter Thiel, he's the founder of PayPal, co-founder, was in an article in there, in Gawker, and he asked them to take it down because the article said that he was gay. And he's a conservative, and he didn't want people knowing that what he was doing in his private life, it's none of their business. And it's before gay marriage became legal. Okay, so he's like really well off, and he's very intelligent, he's well educated, and he's asking them, he's the co-founder of PayPal, former Facebook board member. It says he financed $10 million to help lawsuits against Gawker Media, including the Hulk Hogan suit. Why did he do that? He says it's one of my greater philanthropic things that I've done. It says right here, in 2007, he was outed as gay. Now, what does that mean? I have a gay relative, and my mother was telling her parents that the relative was gay, and he kept denying it. And one day my mom said, you can tell me, I've got lots of gay friends. And then she told on him. So that's kind of like outing as gay. So back in just, a decade or two ago, it was considered criminal to be gay. And if you go even further back, it was considered a mental illness. The APA has since changed their stance. It's no longer considered that. Your orientation is your orientation, right? So anyway, that's kind of your private life anyway. So with invasion of privacy, you can sue for something that's inappropriate, right? Like if somebody's going to ruin your reputation. So, but if the defense is the truth, and so this is public disclosure of private facts. So, unfortunately, if you are, I don't know why. Basically, however, the journalists at Gawker had told the story in 2007, which has been since taken down. After these decades, this case went on for a long time. Okay? They won, then they lost, it's overturned, all the stuff. In 2016, Gawker filed bankruptcy, right? And if you go down to the very end of the case, what they did is they sold off they had a bankruptcy auction. And they also have these other websites, Deadspin, Gizmo, Jalopik, Jezebel, Kodako, Lifehacker. Now, these are journalistic web pages that make money. A lot of money is made by publishing stories that people are interested in the public. And, newsworthy journalism. But some people like the Gawker site. I actually liked it myself personally because they dig deeper and they get stuff that probably people don't want known. And actually, sometimes people contact Gawker, and so was the case with the Hulk Hogan. Maybe I should show you a picture of him in case you don't know who he is. Does this guy look familiar to anybody? He's like a wrestler. Anyway, Peter Thiel helped him out financially with the suit. And some other people, like he said, he spent $10 million trying to knock down this publication. He asked them, please take this article down. And they're like, no. Anyway, so invasion of privacy. Oh, intentional infliction of emotional distress. Now that also goes along with these defamation suits. So a lot of times you'll have different categories which you can add on. Now, It never made it to the Supreme Court, but the fact was there was this tape, inappropriate, sensitive nature, things that are going on in private that shouldn't be public, right? So invasion of privacy. Now this could be somebody's medical records, or you've got HIPAA rights. And so these are the 5: misappropriation, appropriation of one's picture, name or likeness, unauthorized use. There's an example of a gentleman who's famous. They take a picture of him in front of something, and then they say, oh, he likes to drink this beverage, and they're using it to sell the beverage. They're using it for marketing purposes. Like, buy this beverage, this movie star likes this beverage. And then they're like, I never authorized that. And I'm not even making money on it. And they're making money on the ad. And so they can sue. So these are the different ones. Now with the Falselight, it has to be highly offensive. Mischaracterization. And this case was highly offensive, but it wasn't a mischaracterization. Okay? And what happened with Peter Thiel was, well, there's a defense. The defense is the truth, right? So the article was, the other article, I didn't see the other article, but I heard about it. Okay, so basically, at the end, if you read the end of this thing, it says that Gawker Media and Bola reached a $31 million settlement, and also Gawker agreed to forego its appeal. They were appealing, and agreed to remove 3 articles from Gawker. And one of the 3 involved Bola. I have a feeling the other one was Peter Thiel, because I couldn't find it. But if you find it, let me know. So that was a pretty big case. And this other one, Time versus Hill, was a Life magazine review article of a true story. But the story was embellished to make it more interesting and exciting. And basically it's about this family that had been criminally, they weren't harmed or anything. But to make it more interesting, and they made a play about it, they said, oh, this is based on a true story. And then the Life magazine, or the article, wrote on how they were harmed and everything. They weren't harmed. They weren't treated that great, but they sued. They won damages. But Time went on and appealed. They appealed twice, and on the 3rd hearing, the Supreme Court overturned it. So they didn't have to pay anything, but they did have to pay their lawyers a lot of money. And so it was they extended the malice standard in false light invasion of privacy cases. So, and that is based on also New York Times versus Sullivan, another, the standard of malice. You can go to OAS and hear about the case if you want to get something a little bit more interesting on it. As far as what you hear in the news, what you see, images you see, it's like, oh, a picture speaks a 1,000 words. Who's fact checking this? Whoops, that's the wrong one. So yeah, that's the deal here today. And I might try to find and look and see if I can find a actual baby bar or regular bar case that has false light in it, or one of these other ones. But I could not find that politician with the, let's see if this does it. It's still, I think I have to clear my clipboard. Edit, undo, wait, clear contents. Hopefully it's not going to clear. Oh wait, this is Oyas Hill case. That's not the Oyas. Oh no. What happened with that? That is... Okay, so... Where did that go? Somehow... I lost that. Should I go back up there? I had it in there, and then... Hill... 1967. If we can find it. Here it is. Well, I briefly told you about the case. I don't know why. I had this link here, and there we go. Okay, so if you listen to this, if you click on these, you can hear the justices talking back then. And, you know, this is the type of case it is. This is a really long oral argument.
Number 562, Time Incorporated, appellant versus James J. Hill.
Okay, I'm going to put this in here. I'm just going to stick this in here.
Mr. Medina.
Mr. Chief Justice, may it please the court. This is an appeal from a judgment of the Court of Appeals of the State of New York. It involves the First Amendment problem and involves the privacy statute of the State of New York. On trial originally, there was a jury verdict of $175,000, reversed on appeal as being grossly excessive and for prejudicial error. Upheld, however, on liability, with the presiding Justice Botein dissenting in a written opinion. Retrial without a jury, a $30,000 award. That went up direct to the Court of Appeals, affirmed with dissenting, affirmed on the opinions of the appellate division, with dissenting opinion by Judge Fold and Judge Bergen along the same lines as presiding Justice Botein. There are three factual elements that go into this case. First, a 1952 incident in which Mr. Hill, the appellee, and his family were held prisoner by three escaped convicts. Secondly, a book written in 1953 by one Joseph Hayes, later converted by him into a play and a motion picture called The Desperate Hours, which involved a family held prisoner by three convicts. And lastly, a reporting by Life magazine in February of 1955 when the play appeared on Broadway, which involved a prominent mention of the Hill family in connection with the reporting on that play. I think I have two main functions today. First, to tell you about the facts in probably more detail than is normal, because the facts are somewhat complex, but I think once they are understood, the conclusion flows inexorably from those facts. And secondly, to suggest one or two propositions that may lead to what I think is a rather simple solution to this case, which has been overly complicated. And I start with Mr. Hill and his family.
Okay, well, basically the bottom line is this. They sued for the false light. And they were traumatized by what happened, but they weren't injured. The family was unharmed. So they were sort of held captive, but it was just, was anything taken? Blah, blah, blah. Cash, Your Honor. Anyway, so they did not like the story being twisted around, and they said it was a false light, and they didn't like the fact that they were going around saying that it was true, and it wasn't true. So there's a private family that got held hostage in New York by some prisoners that I guess escaped. And they make this whole thing out of it. They publish this article in Life. So whenever you hear of a case, you're going to hear a thing called shepherdizing, which is checking the case to see the latest version of the case. They had 3 cases, same case, same facts, but then they're like, well, you're applying state law. If you look at the Constitution, this is not constitutional. And they, when you have deeper pockets, like a corporation, a media corporation, like Time, which made Life magazine back then, you're going to have deeper pockets for attorneys, and they're going to keep fighting to overturn it. Also, if you go up against the government, that's going to be kind of a losing battle. So it just depends, But a lot of times, this is a tort case, and I know I've studied a lot of cases, so I know that it depends on what policy they want to follow, and basically, journalism is really protected in a lot of ways. It needs to be highly offensive, mischaracterization, and the holding in this case was, that in favor of Time magazine. But I mean, if you get lawyers and they look at the laws, and if you get into an area where you're in a court, some courts tend to be more conservative, some tend to be more liberal, some tend to be, it's just different policies, different beliefs, different values, and of course, right in the center of that is the law, and you want to have a fair and balanced law, right? So there are these different trials that people go through, literally and figuratively. So, torts, invasion of privacy, 4 forms. Here's Gawker magazine now, and it's not a traditional type of it's not very conservative, let's put it that way. And it reports on things that are a little different. They're not following AP News. So like, you've got the journalists that follow the main ones like Reuters and AP, and then you have the journalists that go out on a limb. They really dig, and they find stories that they think are interesting and exciting. And sometimes they piss people off. You got to be careful. They need to train their journalists, So as far as journalism goes, this is one of the areas where you have to kind of know a little bit about the law, and how to. So this needs to go out. Where did we put that link? Did I not get the link? Oh my goodness. Why is this wanting to stay in here? It's because Mercury's retrograde. No. All right. So that's it for today, guys. I just went to the website, and I guess I didn't get the link. Can you believe that? Is it still here? Oh my gosh. Well, you can watch this again if you really want to figure out how to get to that. And I appreciate each and every one of you. Thanks for your time. I won't carry on too much more on this. So if you want to test yourself now, what are the 4 areas? Can you name them off? What are the elements of the 4 areas? What are the defenses? Truth is a defense. Did I put the defenses down? Oh my goodness. I forgot to put the defenses in here. Okay, well, maybe next time we'll go over that. I don't know. I've got to see what I have time to do. And so I will put the link to this video that covers defamation and a little bit on invasion of privacy. I actually looked at the playlist for the Emerson, and I started adding up all the minutes. And I wrote it down on a paper because I didn't realize how long this was. It's 15 hours of law review stuff. I'm afraid I'm not going to be able to go through all of it. I didn't realize that. And I looked at the contracts in the criminal law playlist, and they're not as long. So Torts is the longest of them, and he has the most examples. He started with the hardest, I guess, and the oldest. But remember that third, intentional infliction of emotional distress, because that really goes along with this a lot of times. Not always, but a lot of times. So I think that the defenses are truth. Let me see. Actually, some of the same defenses are the defenses of defamation. We did defamation last time. There's these constitutional privileges, and consent, truth, absolute privilege, qualified. There's overlap between the defamation and the invasion of privacy. And yeah. Okay, well, thanks for listening. I appreciate each and every one of you. I'll see what I'm going to do next. I'm not really sure. Take care. Bye.